Good evening to all of you. Welcome to Legal Matters by Sai Baba Sunkara. So as expected, I think on March 28th, 2022, the bill of Criminal Procedure Amendment 2022 was placed before the Lok Sabha. Of course, a lot of comments were there. Ultimately, yesterday, Honorable Home Minister Shri Amit Shah, he has cleared the air. So many people wanted to raise objections. It is against to equality, right to equality under Article 14, against the doctrine of self-incrimination under Article 20, Clause 3, all these things they have raised, and even Congress people also raised so many objections. You might have seen our MP, Mithun Reddy, he is from Rajampet or something. So he stated that this should not be used as a tool by the investigating officers to go for the political victimization or a political vendetta. I don't know why he has, maybe he might have been involved in that vehicle of that case. I don't know correctly. But this is a thing happening, right? Now, as in Rajya Sabha also it was placed. Anyway, lot of discussion was there, and ultimately on 4th, that is yesterday, 4/4/2022, it was accepted by voice vote. తెలుగులో దీన్ని మోజువాణి అంటారు, వాయిస్ ఓట్. ఓకే అనేసారు అంతా. సో వాయిస్ ఓట్, ఇట్ వాజ్ అడాప్టెడ్. నో వాట్ ఈస్ దిస్ అమెండ్మెంట్ అండ్ హౌ ఇట్ ఈస్ గోయింగ్ టు help the police, how it is going to subject the general public to any defect or to any obstruction or to any violation or something we have to discuss. Basically, before starting this, we will go to the background. In the year 1920, there was an act called as Identification of Prisoners Act 1920. So this act enables the police to take the fingerprints or to take the footprints of the individuals, particularly the persons who are convicted, the persons who are suspected to have been committing offences. So their fingerprints and footprints have to be taken and they have to be preserved. Why? Because they can be searched, they can be compared. If any new fingerprint has come, then they can compare them with the already existing fingerprints of these criminals. Of course, it was allowed as per section 3 of the Identification of Prisoners Act that was there. But the time has changed. Technology has developed. The criminals are always ahead of the police. They are adopting to so many methods. Now the technology, DNA profiling is there. So for DNA profiling, at least the blood sample, the saliva sample, the hair sample, or a tissue of the skin sample, so many things have to be collected. But 1920 Act says only fingerprints or foot impressions. That's all. No other things. Even for that also, we have seen so many acts played by the accused persons. So I think in Allur village, he was VA. At our time, we will call them as village munsif. So actually, he was responsible maybe some misappropriation case. Not able to collect, maybe misappropriation case. So ఆ కేసులో విఆర్ ప్రజెంట్ మున్సిపల్ గారి యొక్క ఫింగర్ ప్రింట్స్ తీసుకోమని చెప్పి వచ్చింది. వెదర్ ఇయర్స్ అంటే ఆయన ఫోర్జర్ వేలు ముద్రలు తీసి రేషన్ వచ్చేసి కొట్టేసాడు ఆ కాలంలోనే. మేబీ నేను తాలూకా 1984, రైట్. So we asked him through court only, we have to take that fingerprints because he was only accused. He was not a convicted person. In that village municipalities, we are very powerful persons at those days. Then through court, we have asked, yes, court allowed them. So on the date of taking the fingerprints, you know what happened? He has almost slit his entire palms with a blade. Blade తో మొత్తం కోసుకున్నాడు. బ్లడ్ ఉంది, ఫింగర్ ప్రింట్ తీయటం మా వల్ల కాదు. సో వీ హ్యావ్ టు వెయిట్ ఫర్ 1 month మోర్. ఎందుకంటే చిన్న గీతలాగా ఇది తీయటప్పుడు 1 month పడి. సో ఇలాంటి వాళ్ళు కూడా ఉంటారు, రైట్. దట్ ఈస్ వన్ అకేషన్. నౌ technology has developed. Not only fingerprints and footprints. Now you have to take the photographs. You have to take the handwriting samples. So many things have come. So to make the police unable to take all these things, this amendment has come. Simply to say that. Right? Now we'll go to the bill proposes to allow the police or particularly, please remember, investigating officers to collect fingerprints, okay, palm prints, okay, photos, iris and retina scanners. Iris and retina. So for suppose a person Aadhaar card, see person morphs another person, or if the person places the photo of another, then the iris will be very exact. Definitely this will be helpful. Iris and retina scans. Then physical and biological samples also. Biological means urine, saliva, blood, so many things. Right? Physical and biological sample. So it will enable the police to take these things. Secondly, please remember, it also enables the police to collect behavioral attributes, that is like handwriting, signatures, then or examination under section 53 ACF. When suppose if somebody receives some burns, he will say, I have to be examined. So rape case, all these things. Yes, all these things have to be done. Right? The medical officer can be directed, can be requested to take his blood samples, like that only you have to do. So all these things the police will be enabled to do. Right? Please remember. So now the Home Minister says so many doubts were raised, and please remember another DNA. So actually in 2019 itself they have brought rules, that is DNA technology use and application, Regulation Bill 2019. So now by taking saliva or hair samples, yes, this is also coming into here. So please remember, ultimately after cleaning the air by the Honorable Home Minister, the opposition members actually they did not press for any amendments. Of course, only some of the members stated that it should be made optional. Why? Because section 20, article 20, clause 3, doctrine of self-incrimination. A person should not be forced to give fingerprints. A person should not be forced to give his blood samples. It should be voluntary. It should be optional. So actually the police are suffering a lot with this article 20, clause 3 only. No doubt it is essential, but IOs are suffering a bit because this is doctrine of self-incrimination. So whenever you are supposed to subject a man for so-called brain mapping test or lie detector test, his permission, the permission of the accused is 100% necessary. Right? That's the. Now with this is gone. 20 clause 3, doctrine of self-incrimination is gone. Right? So please remember, even though people say that it should be optional, but normally it may be difficult. Whatever it is, the court will decide. Right? Now, suppose when the amendment comes, if anybody refuses to give his blood sample, to give his saliva sample, to give his urine sample, to give his hair sample, then what is the offense? So this also you have to know. Section 186 of the Indian Penal Code. Resistance to the orders of, to the directions of a public servant. Yeah, yes, definitely. Section 186. So it is a very non-cognizant offense. So punishment is, I think 3 months, and fine is up to 800, 500, or both of them can. So briefly, this is relating to criminal procedure within brackets Amendment Bill 2022. So which was placed on 28/3/2022, and it passed in the Lok Sabha on 4/4/2022 with a voice vote. So if you know this much, it is info. So now police are more empowered. This video will be helpful to the police also. Yes, now brothers, as investigating officers, you are empowered to take the saliva. You need not go to the court. You need not request the court also, even for handwriting expert of the things. Straight away you can take as per this amendment bill. I think the amendment will come shortly within a couple of days, and police officers will be happy. At the same time, I request you, please don't misuse the same. Right? With this I am stopping. Thank you very much.